Every assault weapon ban in the United States may be standing on borrowed time. A single Supreme Court move, quiet, procedural, but enormously powerful, has pushed the country closer than ever to a ruling that could dismantle assault weapon bans nationwide. This isn't speculation. This isn't hype. This is the Supreme Court taking a decisive step that gun rights advocates have been waiting for over a decade. And what happens next will shape the Second Amendment for generations. And the implications of that question are massive. If the court rules one way, assault weapon bans in states like California, New York, Illinois, New Jersey, Massachusetts, and others could collapse almost overnight. If it rules the other way, those bans could become permanent and even expand. There is no middle ground anymore. The court's latest move signals that the era of ambiguity is ending. This is breaking fast, so make sure you're paying attention, because the legal ground beneath these laws is already shifting. The Supreme Court rarely announces its most important actions with fanfare. There are no press conferences, no dramatic statements. Instead, the real signals come through procedural decisions that most people never notice. And that's exactly what just happened here. By advancing this case at this moment, after years of refusing to intervene, the court is sending a message that it can no longer ignore the chaos unfolding in the lower courts. Assault weapon bans have produced one of the most fractured legal landscapes in modern constitutional law. Identical laws are being upheld in some states and struck down in others, not because the Constitution changes across state lines, but because judges interpret it differently depending on jurisdiction. That kind of inconsistency is precisely what the Supreme Court exists to resolve. And now, it appears the justices are finally ready to step in. For years, gun rights cases involving assault weapon bans were denied without explanation. Even after landmark rulings affirming the Second Amendment as an individual right, the court hesitated to address bans on commonly owned firearms. But that reluctance is gone. The current case has been structured in a way that directly forces the court to confront the issue it has been avoiding. This isn't an accidental development. It's the result of years of legal strategy, careful timing, and mounting judicial defiance that the court can no longer overlook. What makes this case fundamentally different is scale. This is not a challenge brought by a handful of plaintiffs in a single state. It is a coordinated, multi-state confrontation with laws that affect more than 70 million Americans. At stake are bans that criminalize the ownership of firearms that are among the most popular rifles in the country. These are firearms used for home defense, sport shooting, training, and competition by millions of law-abiding citizens. Yet, depending on where you live, owning the same rifle can be perfectly legal or a felony punishable by prison time. That contradiction is no longer sustainable. The challengers in this case include not just individual gun owners, but also local officials, law enforcement leaders, and entire county governments. Sheriffs from multiple jurisdictions have gone on record stating they will not enforce these bans because they believe the laws are unconstitutional. Counties have declared themselves Second Amendment sanctuaries, openly rejecting state-level restrictions. This isn't theoretical resistance. It is real-world refusal to comply, and it has created a direct clash between state governments and local authorities. When laws reach that point, when enforcement itself begins to break down, the Supreme Court almost always steps in, and that's exactly where we are now. At the core of this case is a constitutional crisis hiding in plain sight. The Second Amendment does not change based on geography, yet Americans' rights under it clearly do. A resident of one state can walk into a gun store and legally purchase a rifle that would be illegal just across the border. The Constitution was never meant to function that way. Multiple federal circuit courts have reviewed nearly identical assault weapon bans and reached completely opposite conclusions. Some have ruled that these bans are constitutional. Others have ruled that they violate the Second Amendment. This split has created a system where fundamental rights depend entirely on which appellate court happens to oversee your state. That is the textbook definition of a Supreme Court issue. The court has tolerated this split for years, hoping lower courts would eventually align. Instead, the divide has grown deeper. Judges are not just disagreeing on outcomes, they're disagreeing on how to interpret Supreme Court precedent itself. When lower courts start openly reinterpreting or narrowing Supreme Court rulings, the authority of the court is put at risk. And historically, that's when the justices intervene to reassert control. This case does not exist in a vacuum. It stands on the foundation of earlier Supreme Court decisions that fundamentally reshaped Second Amendment law. Those rulings made two things clear. The Second Amendment protects an individual right, and firearms commonly used for lawful purposes are protected. Assault weapon bans directly challenge both principles. Supporters of these bans argue that certain firearms are too dangerous to be protected. Opponents argue that popularity and common use are precisely what bring these firearms under constitutional protection. The tension between those positions has now reached a breaking point. Lower courts have struggled and, in many cases, refused to apply the Supreme Court's framework consistently. Instead of following clear guidance, they've carved out exceptions, redefined terms, and introduced balancing tests that the Supreme Court explicitly rejected. That defiance has not gone unnoticed. The current case places all of this squarely in front of the justices. It asks them not just to rule on assault weapon bans, but to decide whether their own precedents still carry force. Timing is everything at the Supreme Court, and this case arrives at a moment when the justices are uniquely positioned to act. The composition of the court, the volume of conflicting rulings, and the growing number of states pushing aggressive bans have created a perfect storm. States didn't slow down after earlier Supreme Court decisions. They accelerated. New bans were passed. Existing bans were expanded, and many of these laws were written in ways that seem designed to test how far states can go before the court intervenes. Now, that test may be over. By taking this major step forward, the Supreme Court has signaled that the question of assault weapon bans is no longer hypothetical. A ruling is coming. And when it does, it won't just affect one state or one law. It will redefine the boundaries of the Second Amendment nationwide. To understand why this case has advanced when so many others failed, you have to understand how the Supreme Court actually decides which cases it hears. Contrary to popular belief, it doesn't take a majority of justices to put a case on the docket. It takes just 4. That procedural threshold, known as the Rule of 4, has quietly shaped the future of assault weapon bans for years. And for a long time, that's exactly where gun rights challenges kept breaking down. There were votes, sometimes 3, sometimes even 4, but never the same 4 at the same time. Cases would be discussed at conference, then relisted, then quietly denied without explanation. To the public, it looked like the court was simply uninterested. Internally, something much more complicated was happening. Different justices had different concerns. Some wanted a cleaner factual record. Others worried the cases were too narrow or too broad. Some questioned whether the lower courts had fully developed the historical analysis required by Supreme Court precedent. And some were reluctant to step into a political firestorm without a case that made avoidance impossible. This new case changes that equation entirely. What separates this challenge from earlier attempts is how precisely it was constructed. The legal team behind it didn't just argue that assault weapon bans are unconstitutional. They anticipated every reason the court might use to deny review and removed those excuses one by one. Earlier cases often focused on a single state law. This one does not. It presents a consolidated challenge showing how multiple states have enacted nearly identical bans, enforced them differently, and received contradictory rulings from federal courts. That alone is enough to demand Supreme Court intervention. But the petition goes further. It directly addresses questions individual justices have raised in past opinions and concurrences. Instead of assuming the court would apply precedent as written, the challengers documented how lower courts are actively resisting that precedent. They didn't just claim confusion, they proved defiance. The message to the court is unmistakable. This problem will not resolve itself. If the justices do nothing, lower courts will continue rewriting Second Amendment doctrine case by case, circuit by circuit, and the Supreme Court's authority will erode in real time. That's not something the court can tolerate for long. A key reason this case has gained traction is what happened after the Supreme Court's last major Second Amendment ruling. The court believed it had established a clear framework for evaluating gun laws. The instructions were simple. Courts must rely on text, history, and tradition, not modern policy preferences. What followed instead was widespread resistance. Rather than applying that framework faithfully, many lower courts began finding ways around it. Some claimed historical analogs existed where none were comparable. Others narrowed definitions so tightly that constitutional protections became meaningless. And some openly stated that applying the framework as written would lead to outcomes they considered unacceptable. That kind of judicial behavior creates a crisis. Supreme Court precedent is not optional. Lower courts are not free to reinterpret rulings they dislike. And when they do, the Supreme Court must respond, not just to correct the outcome, but to preserve the hierarchy of the federal judiciary. Assault weapon ban cases have become the primary vehicle for this resistance. Judges defending these laws often acknowledge the controlling precedent, then immediately depart from it. They substitute balancing tests, public safety arguments, and speculative harms, methods the Supreme Court explicitly rejected. The current case lays all of this out in painstaking detail. It shows patterns, not isolated mistakes. It demonstrates that the defiance is systemic, and it argues that unless the Supreme Court intervenes now, the framework it established will collapse under the weight of selective enforcement. The split among federal circuits is not just about legal interpretation, it's about philosophy. Some courts view the Second Amendment as a second-class right, one that can be restricted whenever lawmakers claim a compelling interest. Others treat it like every other constitutional right, subject to limits but not eradication. Assault weapon bans expose that divide more clearly than almost any other issue. Courts that uphold these bans often argue that certain firearms fall outside the scope of the Second Amendment altogether. They label them dangerous, military style, or exceptional, even when those firearms are owned by millions of civilians. Other courts reject that logic outright, pointing out that common ownership is exactly what brings firearms under constitutional protection. The result is legal chaos. Two Americans living under the same constitution are treated entirely differently based on which court oversees their state. That kind of inconsistency cannot stand indefinitely, and the Supreme Court has historically stepped in whenever constitutional rights fracture along geographic lines. This case gives the court a clean opportunity to do exactly that. At the heart of every defense of assault weapon bans is the claim that these firearms are uniquely dangerous. The government argues that they fall outside constitutional protection because they are weapons of war, unsuitable for civilian use. That argument has always been controversial. Now, it's under serious pressure. The challengers have presented evidence showing that the defining features of banned firearms are largely cosmetic. Functionally, they operate no differently than countless other rifles that remain legal nationwide. They fire one round per trigger pull. They are semi-automatic, just like many common hunting and sporting rifles. Yet the bans persist, not because of function, but because of appearance and perception. This distinction matters legally. The Constitution does not protect weapons based on how they look. It protects arms based on common use and lawful purpose. If millions of Americans own and use these firearms responsibly, that fact alone undermines the claim that they are outside the scope of the Second Amendment. The Supreme Court now has to decide whether states can override that principle simply by labeling certain arms as unacceptable. This case is no longer just about assault weapon bans. It's about whether Supreme Court rulings mean what they say. If the court allows lower courts to continue disregarding its guidance, it sets a dangerous precedent, not just for gun rights, but for constitutional law as a whole. Other rights would inevitably follow the same path, with judges selectively applying precedent based on personal views. The justices are keenly aware of this risk. That's why this procedural step matters so much. It signals that the court recognizes the stakes and understands that continued silence is no longer an option. A decision is coming, and when it does, it will either reaffirm the Supreme Court's authority or permanently weaken it. And this is where assault weapon bans face their most serious constitutional threat. The Supreme Court has already stated that firearms in common use for lawful purposes are protected by the Second Amendment. That principle seems simple until courts attempt to redefine it out of existence. Supporters of assault weapon bans now argue that popularity alone is not enough. They claim that even if millions of people own a firearm, it can still be banned if lawmakers decide it is too dangerous. But that argument creates a dangerous contradiction. A weapon can only become common if it is widely owned. If popularity becomes the justification for prohibition, then constitutional protection becomes meaningless. Assault weapon bans rely on this paradox. There are tens of millions of AR-15 style rifles in civilian hands. They are among the most purchased rifles in American history. They are used for home defense, competitive shooting, training, hunting, and recreational target practice. Entire industries exist around them. Training programs, sporting leagues, and safety courses are built on their widespread civilian ownership. If those firearms are not in common use, then nothing is. The challengers argue that accepting the government's definition would allow states to ban any firearm simply by declaring it undesirable. Today, it's rifles. Tomorrow, it could be handguns. The Constitution offers no protection if lawmakers are allowed to define rights out of existence. That's why this case matters far beyond assault weapon bans themselves. When modern policy arguments fall apart, governments turn to history. They claim there is a long-standing tradition of banning dangerous weapons. But when that claim is tested against actual historical evidence, it collapses. At the time of the founding, civilians owned weapons equal to or more powerful than those used by military forces. Muskets, rifles, cannons, and even warships were privately owned. There was no distinction between civilian arms and military arms because the militia was composed of ordinary citizens using their own weapons. That historical reality matters. The Second Amendment was written with the understanding that the people would possess arms suitable for military service, not inferior substitutes, not watered-down versions, arms. Attempts to argue otherwise require rewriting history. The challengers present extensive documentation showing that repeating firearms, high-capacity weapons, and advanced military technology were available to civilians long before modern gun control laws existed. These arms were not banned. They were regulated in limited ways, but ownership itself was not criminalized. That historical consistency is fatal to the argument that assault weapon bans are rooted in tradition. The federal government imposed an assault weapon ban in the 1990s. It lasted 10 years. During that time, researchers studied its effects extensively. The conclusion was consistent across studies. The ban had no measurable impact on violent crime, mass shootings, or homicide rates. Criminals adapted. Law-abiding citizens complied. Violence remained unchanged. When the ban expired, nothing catastrophic happened. Crime did not spike. Mass shootings did not suddenly increase. The dire predictions never materialized. States that continued their own bans after the federal law expired saw no meaningful differences compared to states that never adopted such bans. The data simply does not support the claim that these laws make communities safer. That reality puts courts in a difficult position. Upholding bans becomes harder when evidence shows they don't achieve their stated goals. One of the most uncomfortable aspects of assault weapon bans is where they inevitably lead. Many states attempt to avoid this issue by grandfathering existing firearms, allowing current owners to keep what they already own. But those provisions are temporary by design. Some states prohibit future transfers, ensuring that ownership dies out over time. Others require registration, renewal fees, or compliance checks. Several have openly discussed mandatory buybacks or outright confiscation as a future step. These are not hypotheticals. They are written into legislation, discussed in hearings, and acknowledged by lawmakers themselves. That reality matters constitutionally. A right that disappears over time through attrition is not meaningfully protected. The Supreme Court must decide whether such slow-motion bans are compatible with the Second Amendment. If the Supreme Court rules that assault weapon bans are unconstitutional, the impact would be immediate and far-reaching. State bans would be struck down or rendered unenforceable. Pending cases across the country would be resolved almost overnight. Legislatures would be forced to rethink how they approach firearm regulation entirely. On the other hand, if the court upholds these bans, the consequences would be just as profound. States would be emboldened to expand restrictions further. New categories of firearms could be banned. The concept of common use would be hollowed out, leaving future rights vulnerable. This decision will not be narrow. It cannot be. The court is being asked to define the limits of government power over a fundamental right. The Supreme Court does not move quickly, but it moves deliberately. The procedural step already taken signals that the justices recognize the gravity of this moment. The legal groundwork has been laid. The questions are framed. The conflict is undeniable. A ruling is coming. Whether it restores Second Amendment protections for tens of millions of Americans or locks in permanent bans nationwide depends on how the court answers a question it can no longer avoid. And when that answer arrives, it will redefine gun rights in America for decades to come. If you found this breakdown valuable, make sure to like the video, share your thoughts in the comments, and subscribe with notifications turned on. This case is moving fast, and the next update could change everything.